It's Mike Franklin, the property tax guy, and today we're going to talk about a YouTube video that I saw today regarding a fellow named Lane Myers out in Arizona and his experiences with the court. And I'm going to try to correlate what transpired with him and as to my concerns about as to whether the court should allow me to record small claims assessment review hearings. And at this juncture, the court has denied me my First Amendment right to record these public hearings, and I have a problem with it. But anyway, this guy Lane Myers is out in Tucson, and he's had some interactions with the court system and with their district attorneys out there, and he had a court appearance where he wore a T-shirt that says "Tucson Police Suck," and he wore that into the courtroom, and the judge turned it into a contempt hearing, and because this guy Lane Myers is rather aggressive in his court presentations, he does tend to interrupt the court. He interrupts the opposing party, and he tends to use vulgar language, and the court has a problem with it. He's been involved in a bunch of cases where they're charging him with these ridiculous charges, and he tends to win, but they don't like his style, and and so finally this one judge, apparently he insulted the judge, and the judge had relayed on his website apparently that he'd been a judge for 9 years, when in fact he'd been a law clerk for 6 and a judge for only 3. So apparently he exaggerated his experience on his webpage, and Lane brought that out, and well, apparently that upset the judge. So anyway, they arrested Lane on contempt for contempt, but the judge went on this diatribe talking about the case of Cohen versus California, where this guy back in 1971 wore a T-shirt into the courthouse that said "fuck the draft," and apparently they arrested him for that. But what the judge is saying is that when the guy went to court, he took his T-shirt off and respected the decorum of the court, and well, I might suggest that he didn't respect the decorum of the court. He just knew that he would be dragged off and probably roughed up and thrown in jail. And so I don't know if he actually did respect it. But anyway, the Supreme Court decision determined that he could, in fact, wear his T-shirt in the public areas of the courtroom. But apparently it didn't address what he could do in the courtroom. And so what this judge was suggesting, he was saying that the Constitution says that the Congress shall make no laws, that basically contradict the Constitution. Doesn't say anything about the judiciary violating the Constitution. So he seems to think that Congress is subject to the Constitution, but the judiciary is not. And so they can control free speech in the courtroom. Well, to me, there needs to be limits on that. Should he be interrupting the other parties or interrupting the judge? Probably not. You need to have decorum so that we can have a civil procedure to get to the truth. Should he be using vulgarities in the court? Well, that's a bit of a sticky wicket, because one man's vulgarity is another man's artistry or whatever. What's the definition of vulgar? Who determines what is vulgar and what is not? And so that's somewhat problematic. And as far as wearing a T-shirt, who really cares? What is the court gonna? I have seen that some courts, decide whether or not you're going to wear a suit and tie in court, and But that's ridiculous. I'm going to wear what it is that I wear every day. I don't have to go out and buy a suit for the purpose of it, for the to appease the court. That's ridiculous. But anyway, so they arrested him and threw him in jail. Well, it turns out that the section that he was charged under was not a jailable offense, and the jail couldn't they couldn't figure out how to check him in because the section didn't apply to people who are admitted to jail. So they had to make something else up. They charged him on something else and threw him in jail for that instead. Is my understanding. But so he hurt the judge's feelings, and the judge had premeditated. It's pretty apparent that he was going to have this guy arrested for contempt for his T-shirt that said "Tucson police suck," and it's just it's his opinion, and he has a history to substantiate that might be true. But anyway, how does that pertain to whether or not you can record assessment hearings in New York? Well, I've been denied my right, freedom of press to record these hearings. You can fill out an application for an audio-visual application, and you submit it to the court. And every time I do that, instead of having the hearing by Zoom or in a conference room at the town hall, they force it to go into the courthouse. And then I have 3 court cops surrounding me, making certain that I don't record. It's ridiculous. It's a monumental waste of money. It's just, there's no reason for it. And so I've solicited them to provide me with a legal response as to why I cannot record these hearings. And some of the stuff that they've come up with is Section 735 real property tax law says that there are to be no transcripts of small claims assessment review hearings. So transcript, trans as in translate, script as in scribe, as in writing, transcript, translation to writing. A video is not a translation to writing. But what Section 735 is actually about, it's not about whether or not you can video record. It's about that the SCAR hearings are decided, the cases are decided on determination, not precedent. So the hearing officer makes the determination based on the facts of the case. Case law is not relevant. Other cases are not relevant. Those are the rules. It's determination, not precedent. Therefore, no transcript is necessary because case law is not relevant. But it doesn't mean that there's to be no video recording of it, because video recording is not used for case law. It could be used as something that might be persuasive, but it's not something the hearing officer has to abide by. But it might be something that he'd be interested in hearing. Hear anything that's going to bring justice between the parties. To establish what's equitable between the parties. That's his job. Wouldn't you want more information than less? But no, they don't want it to be recorded. And I'm going to suggest, not because the legislature established that, it's because the court does not want to be accountable to the public, and they're trying to make their job as easy as possible, and they don't want to be criticized. So this is about keeping them from being criticized. It also protects the assessor from being accountable to the public, and that's problematic because the public needs to know how these assessors behave. And if these things were recorded, these assessors would not behave the way that they behave now, which is they're very dismissive towards the taxpayers, and their methodology tends to be arbitrary and capricious. And the public doesn't know that because they don't get to see. But if it were recorded, everybody would be able to see that if the court is doing their job properly, if the assessor is doing their job properly. But they don't want you to have them because that would maybe cause them some work. So it's what I refer to as self-dealing. So anyway, I've asked for specific explanations. One was 735, no transcripts. Obviously, a video is not a transcript, and actually, a court definition is that a transcript is generated by a certified court reporter, stenographer, which is the creation of shorthand to translate speech to writing. That's what a transcript is, and a video is not a transcript. I, as the videographer, am not a certified court reporter, and I'm not creating it for the purposes of generating case law. It's as a check and balance on our government, because it's important that the assessment process be fair and equitable. And video recording these hearings would help establish whether or not that's the case. But they cite the rules of the administrative judge. So it's section 131.1 of the rules of the chief administrative judge. In order to maintain the broadest scope of public access to the courts, to preserve public confidence in the judiciary, and to foster public understanding of the role of the judicial branch in civil society, it is the policy of the unified court system to facilitate audiovisual coverage of court proceedings to the fullest extent permitted by New York civil rights law and other statutes as interpreted by New York courts pursuant to the rules set forth below. As interpreted by the courts. So I guess, so they can do whatever it is that they want. But they're saying it's their intent, to foster the public understanding. Well, then why are they denying this? And then they cite the, subject to the what's permitted by civil rights law, and we'll get into that in a minute. Audio-visual coverage of proceedings in which the testimony of parties were witnessed by subpoena or other compulsory process is or may be taken is prohibited by Civil Rights Law 52. Now, Civil Rights Law 52 is a law that protects people's civil rights. So I have civil rights in that I have a First Amendment right to free press. If other parties in the case, they also have civil rights. And so the court has to weigh whether or not my civil rights impede upon other people's civil rights. And the petitioner in a small claims assessment review hearing, they're my client, and they want it to be recorded. The assessor works for the public, and they have no expectation of privacy. The hearing officer works for the public, and they have no expectation of privacy. So there's no parties to protect under Civil Rights Law 52. Okay, so that's not relevant. Audio-visual coverage of party and witness testimony in any court proceeding other than a plea or an arraignment is prohibited. Okay, audio-visual coverage of party or witness testimony in any court proceeding other than a plea arraignment is prohibited. Okay. There's no witnesses in a small claims assessment review hearing. If that's provided by compulsory process. So this C is referencing essentially Civil Rights Law 52. Audio-visual coverage of party or witness testimony in any court proceeding is prohibited. Well, that's pretty contradictory to their main paragraph. It says nobody can be recorded. It's absurd. And that section is in violation of the First Amendment to the Constitution. It just says it's permitted, period. Prohibited, period. But there's no rational explanation, no legal explanation in any court proceeding. It's just contradictory to everything else in this section. Nothing in these rules is intended to restrict any pre-existing right of the news media to appear at and to report on judicial proceedings in accordance with law. Well, that seems to contradict that. Pre-existing right of the news media to appear at and to report. So what they're saying is that the media can go to the hearing, but they can't record. It's just, we're talking about, back in 150 years ago, there was no cameras, there was no, people would go to the courtroom because there was no recording technology. And so forcing somebody to go into the courtroom or courthouse to report on this thing is it's restricting people's right to know about these things. They are using it to make themselves not accountable. And keep in mind, these are policies of the court. They are not the law. And apparently the court thinks that they are the law. And I just don't think it's appropriate. Other states allow recording. Board of Assessment Review hearings are public hearings, and those were recorded. How is a Board of Assessment Review hearing different than a small claims assessment review hearing? It's the same process. It's the same arguments. It's the same parties. It's the same issues. What's the difference? It makes no sense. No proceeding shall be scheduled, delayed, reenacted, or continued at the request of the convenience of the news medium. It's not an issue because they wouldn't even know that I was recording. I could have a camera in my glasses. I could have a button camera, or I just have a camera sitting right here. The only reason it would become an issue is because they want to make it an issue. There is no issue. They simply don't want to be accountable. So it's in 1776, we kind of had an issue with the tyranny of the British and their rule, which included their judiciary. And so what the judge in the Lane Meyer case is saying is that the Congress is subject to the Constitution, but the court is not. We got rid of the British for these very reasons. And so the court doesn't think that they are subject to the Constitution of the United States. It's ridiculous. They need to, if they're going to deny a recording, they can do so. They can control decorum in the courtroom. But there has to be a logical basis for what they're doing, and there needs to be an appeal process. It just can't be so because they said so. So if they're going to deny me my First Amendment right to record these hearings, they need to provide a logical explanation. If there was another witness that needed their rights to be protected, that would be fine. But there are none in an assessment hearing. There can be in criminal cases, when there's rape victims, there's children. There are instances where those people need to be protected. They have rights too. But there's no rights. Nobody's rights are being infringed in an assessment hearing. There's nothing more public than assessment hearings. And these rules of the administrative judge are unconstitutional. And their denial of my recording these hearings without a logical legal explanation is unconstitutional. And it's improper. The public needs to know what's going on with these processes so that they can have confidence in the process. They themselves said, in order to maintain the broadest scope of public access to the courts, to preserve public confidence in the judiciary, and to foster public understanding of the role of the justice judicial branch in civil society, it is the policy of the unified court system to facilitate the audio-visual coverage of court proceedings. So in order to preserve public confidence in the judiciary, they need to allow these things to be recorded unless it infringes upon somebody else's civil rights. And the court doesn't have civil rights. They work for the public. And they need to allow these hearings to be recorded. And I applaud Lane Myers for much of his behavior. I don't think he should be interrupting people. He shouldn't be getting too extreme with the vulgarity. But it's speech, and he has freedom of speech, and it applies anywhere in this country. But these assessment hearings need to be recorded, so the assessor, the town, the municipalities in general, and the court are accountable to the public. We pay their salaries. They need to be accountable to us. This is Mike Franklin, the property tax guy.